Court of Appeals Division 1, appellate.
Good morning. Please be seated. We are here for oral argument in cause number CV IC20-0051 B&B Holdings DBA Arizona Cardinals Nautilus Insurance versus Sean Morey. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellate's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs. We have discussed this case in conference. We are familiar with the facts of this case. Please bear that in mind when making your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed, and we're going to ask you to use the podium by your table to ensure we're socially distanced.
Thank you. Good morning. My name.
Go ahead and pull that microphone down. Yeah, there you go.
Good morning. My name is Lynette Flanagan, and I represent the petitioners in this matter. I would like to reserve 7 minutes for rebuttal. The decision upon hearing that is currently before you relates to a reimbursement request, and it's probably best to kind of explain how the process normally works, because this case, by all intents and purposes, is an anomaly by the length of time it's been open for active medical care and the way the payment of the providers has been taking place. Typically, a injured worker will go seek care from a provider. The provider will bill the insurance carrier directly, and then the insurance carrier will reimburse the provider in accordance with the Arizona fee schedule. In this case, for whatever reason, the applicant has chosen or has been paying the provider directly and then seeking reimbursement after the fact.
Mr. Morey is getting treatment out of state. That's what necessitated that payment, and his practitioner will not bill workers' comp. Which one is the main factor, or do you know?
Honestly, I don't really know the reason why. The practitioner, Dr. Silver, will not bill the carrier directly. That is true. As far as the other prescriptions and other providers, I just don't believe that the carrier's information is being provided so that they can be billed directly. So the decision upon hearing that was issued in this matter has several errors that are described in our briefing, but just to hit on a couple of them, it's internally inconsistent, and the reimbursements that were awarded without medical support for some of those. And then also the findings were not supported by the evidence. In paragraph 3 of the decision, the ALJ notes that Dr. Silver is prescribing moxifloxacin and prednisolone related to the industrial injury. However, review of the record show that there is no evidence that Dr. Silver prescribes either of these medications. Indeed, what the record shows is that they are being prescribed by a different practitioner, Dr. Nemechek. There's no information in the record to show that they are in any way related to the industrial injury. The next one is the Dr. Silver September 17, 2018 bill. There's no evidence of payment that the applicant paid that bill. Some of the other ones arguably show patient payment, but that September 17, 2018 bill doesn't. And
Can I ask you, I have some fuzziness in the record in some ways that I think really matter. And they're different points than what you're raising, and I understand that. But so help me out, and I will ask questions of both sides along these lines, just because I don't know what happened, and we want to know what happened. There was a hearing, and I'm looking at some notes, set for the 18th of August that then was held. And as I understand it, I think we have a record of what happened at that hearing. As I understand it, the ALJ sort of expected some things to happen after that hearing, some information perhaps to be exchanged. And then there was a hearing on the 1st of September, I think. But we get that sort of from the record by shadows. We don't really know what happened at that hearing. We don't have a transcript from that hearing. And then there's an email that appears sort of after that hearing that was dated the 20th of August. So just a couple of days after that hearing on the 18th. They're not referenced on the decision upon review. The decision upon review appears to me to show some frustration by the ALJ with what had happened and what didn't happen. But if there's any way you can enlighten us with citation to the record about, when this email first appeared, because it seems important, and what may have happened on the 1st of September, because that may be important as well. But those things I'm sort of hungry to better understand.
I wish I could give you more information on what happened on September 1st, but there was no record of it. There was no record made. So unless you were there, nobody knows what actually transpired at that September 1st.
And I understand that, but we certainly were not there, but you or your predecessor or your counterparts or perhaps your client may have been, and we just don't know. Now, and again, we're not a finder of fact, we're an appellate court, so we're quite limited in what we can do, but that causes me at least to struggle.
And unfortunately, because there's no recording of it, it can't even be considered. And I was not there. It was prior counsel was present there, so I don't personally have any knowledge of what transpired at that September 1st hearing either. And that's part of the problem. To the extent that anything that transpired at that September 1st telephonic conference, it forms the basis of the judge's decision, then the decision has to be set aside because you can't give it meaningful review. So that's that part. As far as the email, I think you're referring to the email from Horacio Gracia, the adjuster. And
it was dated the 20th of August, and I think and it appeared, I think, in sort of post-award motion practice, but I'm not sure it was in the record before that, even though it suggests that it might have been if it was actually sent.
So the email was sent to the administrative law judge, the attorney who was representing defendants, and the applicant's counsel on the 20th.
Facially, it looks like that, but I don't know that.
Do you have any sort of confirmation that the email was received? Any communication back and forth between the ALJ, support staff, anyone?
Not in the record. There's no documentation that there was receipt of it at all.
There was no response to it either?
Not in the record.
Okay.
So what's in the record is, and we submitted it as part of our request for review, that, hey, this was before you, Judge, and it was not addressed in the decision upon review either. But that information was provided. That was something that the ALJ had requested at the time of the initial hearing. And then after the initial hearing, the applicant then submitted additional evidence as well. But the defendants never had an opportunity to rebut that evidence, to cross-examine any witnesses. It all was submitted after the fact. But the decision upon hearing, as it sits, awarded reimbursement as submitted, so that includes the reimbursement that was part of that late submission after the initial hearing, for which the defendants had no opportunity to rebut or present evidence on. Hopefully that answered the questions.
It helps me, thank you.
So then, as we were talking about the as submitted, the ALJ's decision talks about billings as submitted, and that's what's being awarded to the applicant. But as submitted, it included items that had previously been reimbursed, part of a prior litigation. As part of the prior litigation, the applicant was reimbursed through March 2017. But one of the submissions includes medications from January 17 onward. So 3 months of medications have been reimbursed, even though the applicant had already been reimbursed those. So that's in violation of Arizona law. There's nothing in the law that provides an applicant who's paying for medications to then get reimbursed twice. The as submitted also included duplicative amounts. If you look through the record, there are different versions of this pharmacy report that has different amounts, different dates. So as submitted, does that mean everything that was submitted? Is the carrier then allowed to go through and say, hey, these are duplicative, these aren't? What exactly does as submitted mean? As I mentioned earlier, the amounts as submitted also included approximately $10,000 in reimbursement requests that were submitted after the initial hearing.
Counsel, let me ask you on the reimbursement point, the primary point that you're making here. Nautilus has paid the entire amount, right? This is now sort of a refund case. Is that fair?
Potentially. In order to allay some of the ALJ's concerns that were articulated in the decision upon hearing, the amounts were paid sort of under protest, but they still wanted to be heard on the merits because the claim is still open, because he's, still self-paying. We needed to address some of the issues that were raised and some of the errors that were raised in the decision upon hearing. So if it goes back to the Industrial Commission and there's a change, then yes, the carrier would then have a credit for any overpayment.
And that, because again, because this comes from the workers, in the workers' compensation area, our alternatives as an appellate court are sort of two, to affirm the award or to set it aside. We don't, unlike if it came from a superior court where there are many things in between those two. But from your perspective, the payment in full doesn't obviate or moot the challenge before this court.
No, Your Honor. And then the final point I just wanted to point out is that the fee schedule applies, and the judge's decision upon hearing.
You said something I didn't hear.
Oh, the fee schedule, the Arizona fee schedule, sorry. The judge's decision upon hearing awards reimbursement as submitted. Doesn't say anything about fee schedule, although early on in the decision it indicates that fee schedule applies, but then the ultimate award awards as submitted. In the request for review, it was pointed out, hey, these amounts are in excess of Arizona fee schedule. And in the decision upon review, that wasn't addressed. It wasn't stated, no, my award means that it is pursuant to fee schedule, so therefore it must mean that she awarded them as submitted. And Arizona fee schedule, Arizona Revised Statute 23908B mandates the establishment of the fee schedule. It's part of the Appendix 8 of the Administrative Code. The award permitting Mr. Morey to leave the state of Arizona specifically provided that medical is going to be paid in accordance with the Arizona fee schedule. Rule 117C also specifically provides that if an injured worker pays a bill, is going to be reimbursed in pursuant to the Arizona fee schedule. To hold otherwise would allow the applicant and the providers to circumvent the fee schedule system, which is a cost containment system. So the fee schedule applies at the bare minimum. In addition to the other reasons set forth in our briefing, the award should be set aside. Thank you.
Counsel, when you're ready.
Morning, Your Honors. I'm going to take a second here just to let my glasses clear after I've taken my mask off so I can see you all this morning. I was at the conference that occurred 2 weeks later. I think this is the bottom line, other than it was not a pleasant conference for defense counsel. The bottom line, which was made very clear in the judge's decision, is that what had been requested 2 weeks before was not done in any way. And that the only thing that happened was that the defense counsel tried to contact the adjuster and no result was given. That did not make the ALJ happy, as it shouldn't have, and she proceeded with the case that we had already talked about as far as what evidence had been submitted and those types of things 2 weeks before. So I think that's the only thing that's relevant as far as that second meeting, which understandably was not held on the record, but the judge references in her decision.
Let me stop you there.
Yes.
Okay, let's go back to that September 1st hearing. Why is it not recorded?
The September 1st hearing?
Yeah.
The initial hearing with the applicant's testimony was recorded,
And that was
and then the request that we meet again in 2 weeks.
the August 18th, your client did provide
Correct.
testimony. We fast forward to September 1st. This is where the majority of the decision-making appears to have taken place. It was in August.
You know what? I'm sorry, Your Honor.
Let me finish. In August, we need to figure out what's outstanding, and in September, you haven't done what we said you were supposed to do. So why wasn't that reduced to the record so that we have that to review?
That I don't have the answer for. Only the ALJ could answer that question. But I can tell you this, the majority of the decision-making was not made in that meeting. The decision-making was made in the August 18th hearing. The defense counsel, the ALJ requested certain specific things from defense counsel, and those were not provided as the judge indicated in her decision. Other than that, there was no decision-making. The testimony was taken at the August 18th hearing. The records that were submitted were considered, along with other records that were placed in after that date, which is not unusual in these cases. ARS 23941F does not bound the commission by technical rules of evidence. It can be conducted in any way that where substantial justice is is given in these cases. And it's not unusual that medical records that may have been received late are submitted. Defense counsel certainly could have done that in this 2-week period.
Did defense counsel not send through their adjuster the list that the ALJ requested as evidenced in the request for review?
No,
You never received it.
nothing was done in those 2 weeks by defense.
Counsel, can I ask, to follow up on Judge Campbell's good question more pointedly, we do have in the record an email that's dated the 20th of August, just 2 days after that August 18 hearing where your client did testify. What I can't divine is when that first became part of the record. I know, you know, in sort of post-award motion practice, if you will, it did. But I don't know where it is before that time, and I sure don't see it in the administrative record from the 20th of August.
The answer is nowhere. That is the first time it showed up. Certainly was not discussed at the September 1st post-hearing conference.
And let me ask you, and I appreciate what you're saying, and I appreciate that you were there. Of course, we weren't. And we're a paper review court. We don't deal with the human condition like, you know, testimony and things like that. But where would we look in this record to best divine what happened at that September 1 hearing, which otherwise is sort of invisible to us?
And my response to that is the details, I believe, of that September 1st post-hearing conference are not relevant. What is relevant is the fact that certain things were requested of the defense counsel and the defense and the employer and the insurance carrier. Clearly, in the paper record that is there, those were not done. And that is why the administrative law judge proceeded.
Let me ask.
Go ahead.
Let me ask you with that. The one possible exception, and again, we're struggling with this, is that August 20 email, which appears responsive from what was discussed and testimony received on the 18th of August, but doesn't appear in our record until the 13th hour, if you will. But it also isn't addressed in the decision on review, which is sort of curious. I'd be interested.
Your Honor, it's not curious because it wasn't there. That's why it wasn't addressed. It wasn't there. Until you first see it in the paper record, it was not there.
Let me broaden it a little bit. In a situation where an ALJ or a judicial officer says, hey, parties, here's what I need you to do by this date. And I get, you know, we get that flavor from the August 18 transcript. If those things did or did not happen, I would expect that we would see some reference to that, and here the argument at least is that those didn't happen, but nowhere is that referenced in the decision upon review. It's as if that never happened, and that causes me to struggle.
Very good. Judge Campbell?
He succinctly asked the question I was percolating in my mind. Where does it say that nobody got this? This is the first time we've seen this. This wasn't compliance. I mean, just like we have candor to this court, everyone has a duty of candor to the ALJ. So if that's attached to the record for review, why wasn't it addressed in the response or the court's order?
I think, and once again, I'm talking for the ALJ here, but I think from her standpoint, as I believe is evidenced in the decision upon hearing, certain things were requested, they were not done, and at that point, it was time to issue a decision after years of waiting for these reimbursements to be paid.
And I'm very sympathetic to Mr. Morley, but when I look at this case and the documents provided, it appears that they complied to a certain extent based on that email, and the court, so we should disregard it simply because the court said they did not comply in the original award and didn't even address the email in the subsequent review?
The email I believe you're referring to was one that was written by the adjuster, if I recall. Are we referencing the same email?
Yes, sir.
First of all, what the adjuster brings up is not valid. He's talking about not getting medical records, and there's two things that I would say about that. First of all, the obligation to provide medical records is not on the applicant. It's on the physician. That's Rule 113. Okay? There is no obligation on the part of the applicant to get reimbursement to provide medical records. That is in Rule 117, and I don't want to tell you the wrong rule. I have it right here. I have it here, which is C, which is when you're talking about reimbursements, this is R25-117C, that there needs to be an itemized statement presented. But there's no talk about records, at least on the obligation of the applicant. That was the main gist and thrust of that email. And that's not a requirement on the part of the applicant to have these expenses reimbursed to him. So to that extent, the email is irrelevant to anything that we're doing here as far as this decision is concerned, finding that these medical procedures and that the providers were covered as reasonably necessary, and then finding that the actual out-of-pocket expenses should be reimbursed to the applicant.
And I agree that that is the case, especially when we're using workers' comp medical providers. This is kind of a unique and strange case in the fact that he's not getting treatment in Arizona, and that he was given permission to get treatment in another state. And so we don't have that relationship with this physician. Was there anything that clarified whose burden it would be to provide the medical records when it was initially authorized?
Yes.
And point me in the record to where that is.
Well, as far as specific, who must provide the records?
Yes, sir.
No, there wasn't. But there is, as I say, this particular 1061J hearing can't be considered in a vacuum. There was two very similar 1061J hearings that occurred since 2012. And there is, in those decisions, how it was decided to go forward as far as the reimbursement of prescription costs, which is 95% of what we're talking about here, but also visits. And I brought those because I think it's very specific to hand out in the record, if I may approach, Your Honor.
And I'm going to have our bailiff grab those from you, and she will disseminate them. Thank you, Mallory. And did we get a copy for opposing counsel?
Yes, I had indicated which ones we'd be using.
Thank you.
As a result of the initial 1061J, there was an agreement made, and I've highlighted that. This is on page 2 of the decision upon hearing in that case. Medications prescribed by Dr. Flanagan, he was the treating physician at that time, and then it lists those medications. Applicant will cover the medications and submit receipts or a monthly statement from the pharmacy, which will be reimbursed by the carrier, provided there is evidence the medications have been prescribed by Dr. Flanagan.
So was that by stipulation of the parties' counsel?
That's correct.
Okay, so that stipulation isn't an order of the court, that's an order of the court adopting a stipulation of the parties.
That is the order of the court adopting that stipulation.
So would that be binding moving forward?
In the sense that the doctors in this particular case, Dr. Silver, who had done most of the prescribing and was referred to Mr. Morey by Dr. Flanagan, that changes in assent. But the practice, to be able to say that this 1061J just appeared out of nowhere, the practice of the applicant paying for his prescriptions and then being reimbursed was not new, and had been approved, and had been accepted, and that's what had happened several times. The other packet that I have there regards, and by the way, you'll see that there is nothing here referencing any kind of deduction for the fee schedule, not a word. Okay.
But again, that's by stipulation. It wouldn't be binded in a contested kind of activity, would it?
It would be binding in the sense that it shows the pattern of what the defendants are willing to do for an out-of-state person who is having to get his medications by paying for them out of pocket. In that sense, the actions of the defendants. Then we look at...
Well, can the defendants change their behavior from time to time, depending upon their circumstances as they proceed?
I don't disagree with that statement, depending upon the circumstances, but there is nothing that's changed in these circumstances. These are essentially the same medications done by essentially the same doctors as we've been fighting about now for 9 or 10 years, close to 10 years, which is the point about the medical records that were submitted from our side afterwards. If the defense is going to say that they were somehow surprised by these records, that's not credible. These were if you look through the records as far as the submission, those CVS printouts that you see that say this is how much was paid, this is the doctor who prescribed it, this is the medication, those have been the same since 2012. And that's all that was submitted in this case. And so for the defense to somehow act like we did something entirely out of the ordinary that surprised them and now they have to go through a whole hearing process is not supported by the record. What was being done in this case is the same thing that had already been done twice before. Very recently, I might add. These date back, the prescriptions that we're talking about, to January of 2017. We were actually in the second 1061J proceeding when these were being incurred. And so there's very little difference between the proceedings that we're talking about. Going to the fee schedule, because I think that's an interesting question here about how fee schedules apply to out-of-state applicants or injured workers. And to complete my thought as far as what the pattern was in this case, because in this case, Mr. Morey was given permission in 2011 to leave the state. Now understand, We're talking, the one thing I showed you as far as what the carrier had agreed to was later in 2012, as was the decision upon hearing from the administrative law judge in 2019. If we look at the first page, I've highlighted a couple of numbers. The fact that there have been reimbursements of $12,762.58 and an agreement by the defendants that another $17,719.42 would be paid upon the approval of the stipulation. If you add those two together, Your Honors, you get an amount of $30,482 and no cents. And you don't have to take my word for it, you can add it up if you'd like. The other two documents that I have excerpted from the record were attached to the initial 1061J hearing that resulted in this decision upon hearing. If you see, what was being requested in that 1061J is the exact same amount, $30,482. It was stated twice in that 1061J request. There's no reduction there. There was no fee schedule reduction. There's never been a fee schedule reduction. Now, I've used the prescription costs, but that applies also to the doctor's fees. There's never been a fee schedule reduction, not in 9 years for these visits.
So would that preclude the carrier from, at this point, demanding that the fee schedule be applied from henceforth?
And that leads to my next subject, which is the fee schedule cannot apply to an out-of-state injured worker. Now, I understand that we have two rules that seem to be in conflict, don't they, in 117. One is that the injured worker cannot be held responsible for the disputed part of the bill. And that is exactly what would happen in this case if full payment and reimbursement wasn't made. On the other hand, the rule also says that the doctor would be paid or the provider, or in this case the pharmacy, by the fee schedule. So we seem to have a conflict here, don't we? Now, the Arrowhead Press case, I think, speaks directly to that. And basically, in that case, it was held that at that time, the law's changed now, but pharmacies weren't subject to the fee schedule. Therefore, as Arrowhead Press said, the commission doesn't have jurisdiction over them. So what do we do as far as applying any kind of a fee schedule? And the court held that in that case, recognized that the Industrial Commission isn't a court of general jurisdiction. It has jurisdiction only over certain parties, the applicant, the employer, the carrier, medical provider, when we're talking about the fee schedule. But in this case, it didn't have it over the pharmacy. And there it said, but the commission still has jurisdiction over the the carrier and the claimant. And that's what was done here. The ALJ did have authority. I know the defense wants to say she has no authority to say whether the fee schedule should be applied or not applied. She does. Arrowhead Press gives the ALJ the right to do that, and that's what she did in this case.
Thank you,
All right.
counsel.
Thank you.
When you're ready.
Thank you. I just want to follow up on a couple of things. Counsel talks about the Arrowhead case. The Arrowhead case was prior to the pharmaceutical fee schedule being adopted, so it really isn't applicable. But even if it was applicable, the ALJ here needed to make some sort of determination on reasonableness, and she didn't do that. There's nothing in her decision upon hearing that makes any kind of determination as to the reasonableness of these charges. Second of all, the prior decisions aren't applicable here. The first one that was cited from 2013, those prescriptions were supposed to be prescribed by Dr. Flanagan, who's a neurologist. Dr. Flanagan hasn't been prescribing any of these prescriptions. They're now being prescribed by a psychiatrist, Dr. Silver. So that stipulation doesn't apply to somehow put the carrier on obligation to rubber stamp any kind of reimbursement that comes in. Plus, the amounts of these prescriptions have changed. Even in the submissions that were provided as part of this 1061J, they have fluctuated in the amounts based upon the same prescription. Also, not all the medications that are currently part of our 1061J were even part of that stipulation and subsequent award in 2013. And then as it relates to the recent award from Judge Powell, the prior litigation, that was very specific that it only goes through treatment through March 2017, and it specifically does not apply moving forward. So that can't be held to somehow obligate the carrier to those prior decisions and to act consistently with those decisions. There's also a mention of the applicant has no obligation to provide medical records. Back, as I said in the beginning, the process typically is the provider bills the carrier, and in order to get paid, he has to provide the medical records every 30 days. That's Rule 113. That's how it typically works. Well, here the process isn't working, and if the applicant wants to be reimbursed, he needs to still show medical relationship, medical causation for his condition, the treatment he's getting to the industrial injury. Otherwise, he can submit any type of medication, and the carrier would just automatically have to pay it. That's not what the rules envision, and that's not how the process should work. He still has to show medical causation for the treatment related to the industrial injury. And just to clarify, in the prior decisions, there had been fee schedule reductions, and I think it's identified in our briefing, specifically where a couple of the providers, it was indicated that they would be paid according to fee schedule. So it's not like the carrier has abandoned the fee schedule. They haven't. The fee schedule is still the law. They can agree otherwise from time to time, sure, but it's still the law, and it's still should have been addressed by the ALJ in her decision here. But we don't even need to get to all of that, because some of the points or some of the bases for the ALJ's decision just simply aren't supported by the record. And that's the two medications I discussed earlier, and the one bill from Dr. Silver showing no proof of payment whatsoever. I mean, while she should have addressed the fee schedule, while she was in error to not have the award consistent with the fee schedule, or to otherwise make some sort of determination on reasonableness, even beyond that, there isn't evidence to support portions of her decision, and for that reason, it should be set aside.
So let's talk about this taking place in another state, in the Arizona fee schedule for physicians and pharmacies not applying. You said that the case cited by opposing counsel should not apply, and even if it did, it wouldn't. How are we supposed to deal with billing people in another state when we have no jurisdiction over the providers or the pharmacies, and this fee schedule? Explain how you see that working.
Just as it would here, the fee schedule, the provider provides treatment, and they want to get paid. And the award that allows the applicant, and it's not just this applicant, it's any applicant, so they can have freedom of movement, and they're not tied to Arizona. They should be able to go move to another state if they want to, but that doesn't relieve any of the laws of Arizona over the providers. If they want to get paid, then they're going to follow the rules.
So we've got a statute that says that the claimant, the injured party, isn't supposed to pay, right?
So what the rules say, so there's two, there's A, B, and C. And A and B, it's when we're working under the normal process where the carrier's billing, or the provider's billing the carrier, and the carrier's billing the provider then can't go back to the injured worker and say, hey, they didn't pay me enough, you need to pay. So that's what A and B are. C is if the applicant pays the bills, he's only allowed to get reimbursed pursuant to fee schedule. That's what it says. And so the applicant's issue is now with the provider. Hey doctor, I'm not getting reimbursed for all these. I still want to treat with you, but this is all I'm getting reimbursed. This is all they're going to pay. It's now between the injured worker and the provider. Or the injured worker can go find a provider who's going to accept fee schedule, and that would happen here too. There's some physicians that refuse to treat patients who are workers' comp because they don't want to be obligated to the fee schedule. So then that injured worker needs to find somebody who is willing to, and there's plenty of physicians who will. It's not, the fee schedule isn't some horrible draconian, not great reimbursement. I mean, it's a pretty decent reimbursement, and so it's not a penalty to any injured worker to have to find a doctor who accepts a fee schedule.
Thank you.
Thank you.
Any questions? Well, council, you've given us much to consider. We will take this matter under advisement and issue a written ruling in due course. We thank you for your arguments. Please be safe out there. We are adjourned.